Good afternoon and welcome to CCAT's virtual symposium, Listen and Learn, All the Stories to be Told. Today's session is called Critical Theories for Tribunals. Bienvenue à toutes et à tous au colloque virtuel du CTAC intitulé Écouter et apprendre, tant d'histoires à partager. I'm Carmel Salmon-Labbé, member of the CCAT Symposium Program Committee and Associate Director at the Office of Appeals, Discipline, and Faculty Grievances at the University of Toronto. So before we start with the actual substance of the program, I would like to do the land acknowledgement. And because I'm a resident in the city of Toronto, I will be acknowledging the lands that we are on, or that I am on, based on the City of Toronto's acknowledgement. So I acknowledge that we are on the traditional territory of many nations, including the Mississaugas of the Credit, the Anishinaabe, the Chippewa, the Haudenosaunee, and the Wendat peoples, and is now home to diverse First Nations, Inuit, and Métis peoples. I also acknowledge that Toronto is covered by Treaty 13, signed with the Mississaugas and the Credit, and the Williams Treaties, signed with multiple Mississaugas and Chippewa bands. I am grateful to have the opportunity to work on this land. As you're all aware, the symposium is being presented virtually again this year, but that hasn't stopped the program committee from presenting what CCAT has become known for, a diverse and thought-provoking program that will inspire, educate, and empower those of us in the administration justice community. Comme vous le savez, nous sommes tous impatients de se retrouver en personne. Toutefois, puisque la planification du colloque débute environ 1 an à l'avance, nous avons décidé d'organiser un événement virtuel afin de tenir compte des préoccupations et des restrictions liées à la pandémie. Nous espérons pouvoir organiser des événements en présentiel très bientôt. If you've been participating in past sessions, you can sit back and relax for a couple of minutes. For those of you joining us for the first time today, there are a few housekeeping details that I need to let you know about. So if you'll be participating in next week's sessions, please check your inbox for the login details for Wednesday, May 11th. Please check your spam or junk folders if you don't see the email in your inbox. And if you still can't find your login information, please email for the CCAT office, or sorry, please email the CCAT office at info@ccat-ctac.org. We'll post the email address in the chat. For those who purchased a full series registration, you'll receive the links to the webinar recordings, and we're pleased to provide simultaneous interpretation services for the webinar series. To activate this feature, please click on the simultaneous interpretation button located at the bottom of your screen. That's the icon that looks like a globe. Select your preferred language, English or French, and select mute original audio. We hope that you'll actively participate in all of our sessions through the Q&A and chat today. So the Q&A and chat buttons are located at the bottom of your screen. Please use the Q&A to ask questions to the panelists. If there are questions in the Q&A that also interest you, please upvote those questions and we'll get to them first. Sentez-vous bien à l'aise de converser avec les autres participants en utilisant la fonction chat. Il s'agit d'une excellente façon de partager des ressources, des idées et des hyperliens. Please use the chat if you experience technical issues. So now we'll turn to our speakers. So although you can find our bios on the CCAT website, I'd now like to introduce each of our outstanding panelists for today's session. We'll start with Dean Donna Young. She's the founding dean of the Lincoln Alexander School of Law at Toronto Metropolitan University, which was formerly known as Ryerson University in Ontario. And before assuming her deanship, she was the President William McKinley Distinguished Professor of Law and Public Policy at the Albany Law School, a joint faculty member at the University at Albany's Department of Women's Gender and Sexuality Studies in Albany, New York. And her research focuses primarily on law and inequality, race and gender, discrimination, and academic freedom and university governance. Dean Young's contributions to the legal profession in Canada is so remarkable, and she's been recognized in numerous ways, including being a recipient of the Canadian Law Awards Female Trailblazer Award, Top 25 Women of Influence Award, University College Alumni of Influence Award at the University of Toronto, and Toronto Life's 2020 Most Influential Torontonians. Thank you for joining us, Dean Young. It's a privilege to have you speak at our event today. Ms. Adelia Bay is a scholar and PhD student at Osgoode Hall Law School, York University in Ontario as well. Her expertise lies in disability legal studies. This fascinating field brings together legal theory and critical disability studies to understand the role of law and legal institutions in the construction of disability. Adelia's dissertation project focuses on how workers with episodic disabilities balance the competing needs of self-care and work. She's a published author and has published internationally on this topic and other related topics. And most recently, she co-authored a book called Law and Disability in Canada, Cases and Materials. It's a LexisNexis publication. Congratulations on that, Adelia. Adelia holds a Master of Laws from Columbia Law School in New York City, where she graduated a student fellow with Columbia University's Future of Disabilities Studies project. She holds a JD in English Common Law from University of Ottawa, and also has a Bachelor in Journalism from as well the Toronto Metropolitan University. Adelia is working to help found the Canadian Association of Lawyers with Disabilities, l'Association canadienne des juristes en situation de handicap, and she's also one of the coordinators for the Disability Legal Studies Critical Research Network with the International Law and Society Association. We're very fortunate to have you join us, Adelia. Thank you. Chief Commissioner Patricia DeKeer. She is the Chief Commissioner of the Ontario Human Rights Commission. Patricia is constantly working to ensure access to justice, equality, and equity. Before being appointed Chief Commissioner of the Ontario Human Rights Commission in August 2021, Patricia served as Deputy Judge with the Ontario Superior Court of Justice. She served on various tribunals and boards, including the Human Rights Tribunal of Ontario. She played leading roles in many equity organizations, particularly related to anti-Black racism. She's a constitutional law scholar and is a mentor and coach for numerous, maybe hundreds, Patricia, of people and adults in the legal and other professions. She has also volunteered with CCAT a few years ago, so she's very familiar with the great work that the CCAT does. We are honored to have you as well with us, Patricia. Thank you for joining the conversation. So the way we will have the presentation is that Donna and Adelia will discuss critical theories from the perspective of academia. And because most of us who are attending today are in the trenches, working in administrative tribunals or boards or commissions. So Patricia will bring everything together for us by discussing critical theories from a practitioner's perspective. So I hope everybody enjoys the discussion that we'll have today. And without further ado, I'll now ask Donna to start the discussion with our first question. Donna, what is the definition of critical theory as it pertains to race, gender, etc.? And please let us know also if there are any misconceptions.
Sure, thank you so much. Good afternoon, everyone. I'd like to thank the event organizers for inviting me to share some of my thoughts on what I consider a very important topic, the role of critical race theory and other critical approaches to the law and legal practice. Before I do that, I'd like to acknowledge that May 5th is the National Day of Awareness for Murdered and Missing Indigenous Women and Girls. This day is recognized as Red Dress Day, a day to honor, recognize, and raise awareness about a national tragedy. Before I became dean at TMU, at the law school at TMU, I was a law professor in the United States, and I examined the role that race and gender played in the regulation of employment, in interpretations of criminal laws, and in access to justice through federal civil procedure. But I'm a Torontonian and the product of two Canadian law schools, UBC and Osgoode, where I first encountered the writings of the founders of critical race theory and influential feminist scholars in the early 1990s. It was in the early 1990s that was a very important time for feminist legal theory and critical race theory. Feminism or feminist legal theory was making inroads in Canada, and even though charter jurisprudence was still in its infancy, lessons from Canadian feminist lawyers were finding their way into judicial decisions, legislation, and international initiatives. Women law professors and lawyers were bringing cases to the courts and tribunals that they were writing articles, books, op-eds, they were making films, and they were contributing to Royal Commission reports and inserting a feminist voice into the law school curricula. They were urging more inclusivity of perspectives in legal analysis and doctrine. And meanwhile, in the United States, women lawyers and law professors were also making quite an enormous impact. Some of the more significant inroads in Canada and the United States were seen in jurisprudence around sexual harassment, pregnancy discrimination, parental leave policies, equal pay and employment equity, rape shield laws, adoption, marriage equality, abortion rights, and a host of other areas. If you have read the newspaper in the last few days, you will see that many of these factors or these issues are now under attack in the United States. But the net effect was this increased integration of a gendered lens in the ways laws were drafted, interpreted, and implemented. However, Canadian law schools were not particularly diverse in terms of the racial demographics of the faculty or student body. The number of professors of color in Canadian law schools right through the 1990s was extremely limited. But the curriculum was expanding nonetheless, and issues of race and gender were gradually being incorporated. In the United States, but not so much in Canada, analyses of racism and colonialism were being incorporated into mainstream legal analysis, though through the activity of a group of lawyers and law professors of color who had begun to organize around a new way of examining the law. These were the founders of critical race theory, who were dedicated to highlighting the ways in which race and racism were infused in legal processes and structures, and committed to using various rhetorical and practical devices to address systemic bias and racism. This movement was a response to the almost complete erasure of Black, Latino, Asian, and Indigenous voices in analyzing, interpreting, and implementing the law, and out of a deep frustration with the still dominant idea that racism was an aberration that could be eliminated through anti-discrimination laws, without any deeper appreciation that the legal system itself was inherently anti-egalitarian and intertwined within a system of white supremacy. Now, let me step back a bit here and explain something that at first seems obvious, but was not and is not always the case. The outcomes of legal disputes often depend on who has the better story. The story can be a legal one, whose story fits better into the theory of the case, but it also depends on how the story resonates with and is understood by the decision maker. To understand how law is practiced, we must first appreciate that disputes consist of different and sometimes contradictory stories about the same problem. In other words, the law is replete with stories and dedicated to determining whose stories are the most persuasive. Judicial opinions and administrative decisions sometimes tell very different stories. And so it's not uncommon to read majority and dissenting opinions that have little in common with each other. The founders of critical race theory dedicated themselves to telling the stories that weren't being told in the law. It begins with the premise that racism is normal. It permeates, and this is where we go to the definition of critical race theory. It begins with the premise that racism is normal. It permeates our lives. It's embedded within systems and institutions like the legal system that replicate racial inequality. That racist incidents are not aberrations, but instead are manifestations of structural and systemic racism. And that even though overt intentional acts of discrimination are to be found scattered throughout workplaces, educational institutions, healthcare and housing and public services, structural and systemic discrimination is even more pernicious and destructive and is almost completely resistant to attempts at redress through human rights laws and processes. It leads to the privileging of the experiences and perspectives of those whose identities are aligned with those in power. And racism leads to, the systemic racism leads to persistent social and economic inequities that manifests in some lives mattering and others not. Black lives don't matter, for example, under political, educational, and legal systems that were designed and instituted with the purpose or effect of maintaining white supremacy. So what is the definition of critical race theory? It's quite well known for anyone who is practicing it or who is engaged in it, and it is completely either misunderstood or turned on its head by those who, for political gain, mostly for political gain, have taken it as this buzzword to argue against any historical perspective that deals with either in the United States, slavery and racism, in Canada, colonialism and slavery, anything that kind of gains political power. And so now we have in the United States, and we know how this happened, right? We know that this was a political ploy, but we know now that in the United States, there are 27 states within the Union who have enacted legislation banning critical race theory. But critical race theory as it is defined through this legislation does not appear at all to be the critical race theory that I am talking about, which is a theory that is based on an analysis of inequality, right? Based on an analysis of inequality. It is not racist to look at the legacy of slavery, inequality, discrimination, and call it out. That is not racist, but those who challenge critical race theory have turned the theory upside down until it is almost completely unrecognizable to those who actually understand what it is. So I'll leave it there for a bit, but I do want to say that when, Canada is very proud of a national identity that we see ourselves as caring and fair-minded people. There's a lot of lofty legal doctrine that supports this idea. And some of it is true. I chose to come back to Canada for a really good reason, but I do want to say that we Canadians remain astonishingly tolerant of inequality and injustice, and therefore critical race theory, critical disability studies, feminist jurisprudence, queer theory, all have a role to play in bringing to light in the myriad ways in which we continue to be tolerant of inequality and injustice. And I'll end there. Carmel, you're on mute.
It never fails. Thank you for this very exhaustive answer. It's very helpful. My second question is, what is intersectionality and why is it important to understand this concept?
Right, so this is another idea that kind of originated in the 1990s in the Legal Academy with Kimberly Crenshaw, who coined the term. She wrote a seminal 1989 piece that has been, that was extraordinarily influential in understanding what intersectionality is. This is another concept that has been kind of twisted and misidentified and and used for political purposes. But for purposes of understanding what it means, it's an analytical framework for understanding how aspects of a person's social and political identities combine to create different modes of discrimination and privilege. It's a lens or a prism for seeing the way in which various forms of inequality operate to exacerbate each other. We tend to talk about race inequality as separate from inequality based on gender, class, sexuality, or disability. What's often missing is how some people are subject to all of these. And the experience is not just the sum of its parts. These intersecting and overlapping social identities may be both empowering and oppressing. We all know, and so just a kind of a couple of examples. If we look at things from a gender perspective, we know that the average woman is paid less than the average man for the same work, right? We know that. That is clear. And over time, we see that this inequality over the life of an individual woman, but also in the aggregate, forms this pattern. And that pattern we have been talking about, or we theorize as the feminization of poverty. Poverty affecting women disproportionately. So now let's add a racial lens, because not all women are the same, right? And if we see that, we can see that there are these structural inequalities between men and women, but there are also structural inequalities between white women and women of color. So we know, for example, that there's a lot of difference in the United States, for example, where white women's median wealth is somewhere around $40,000, whereas Black women's median wealth is $100. If we only look at gender, the Black woman's experience is subsumed in this category of women. And we don't see the real racial impact of the gender discrimination. And we can say this about race too. Single Black men, their median wealth is $10,000 compared to single Black women's median wealth being less than $2,000. So if we only look at the racial lens and fail to consider gender, we are missing the lived experience of people, women, Black women, who are at the intersection of an experience of race and gender discrimination. So Black women, for example, and this is all part of Kim Crenshaw's theory, lie at the intersection of two disadvantaged identities that cannot be defined fully through either one of those categories. That's what intersectionality is.
Thank you, Donna. My next question, what do you want tribunal adjudicators and leadership to know about how their structures and policies impact all stakeholders involved in their proceedings? Parties, self-represented litigants, counsel, legal representatives, adjudicators, etc.
So I'm going to cheat a little bit and not directly answer that question, because I think that the audience members are much more well-versed at answering that question than I am. But I do want to make a few suggestions, because it's not just about administrative tribunals, and it's not just about this particular context, right? If you take systemic discrimination and systemic oppression seriously, then we all have a role to play, including higher education, law schools, the legal profession in general, right? So any kind of advice that would be given to tribunals, administrative tribunals, could be adapted to a whole range of things. And so I'm not going to try to attempt a fulsome answer, but I will say that if there's one thing that critical race theory and feminist theory have taught us, is that we have to listen to the stories that are being told differently. Right? Critical race theory tells us to listen through a racial lens. And that's not racist. To do that is not doing something that is racist. It is, we're paying attention to race, right? Which is a non-colorblind approach, because colorblind approaches produce the inequalities that these lived experiences of racialized people actually experience. So we've got to pay attention to what's going on, not just in the legal doctrine, not in just the disputes, but into the interrelationships of all of the parties that might actually determine why someone has experienced a particular issue, or why their argument is this way, in a way that kind of makes it so more holistic. Understand the situation, not from a colorblind perspective, but from a perspective that pays attention to the identity of the parties or the people before you, and takes that into consideration in the treatment and the outcome of the dispute.
Thank you. My next question. How can we better design tribunals to be accessible to everyone and meaningfully respond to different voices?
I'm going to fudge again.
That's what
but I will, because it's a similar question, but I'm going to fudge a bit. But I do want to say that good diversity training, right? Not all diversity training is good, but good diversity training will help us deal with our own kind of biases, stereotypes, so that we can actually pay attention to that racial lens that I was talking about. And we all have a racial lens, right? We all do. We all have our own blind spots or our own ways of not seeing certain things and experiences. And, you know, making sure that we are training ourselves and being conscious of it will help, I think, all of us, again, to do our jobs better.
Thank you. And the last question for you, Donna. A lot of self-represented litigants come before administrative tribunals. Can you talk about how we should view the power dynamics through the lens of critical theories?
Sure. Again, this is going to be short. Self-represented litigants are already at an enormous disadvantage within the system that favors repeat players, right? And those repeat players are the judges and the lawyers and the employers and the companies and the service providers that are brought before tribunals, right? That have a familiarity with tribunals and courts. So anyone who is representing themselves in a often very complicated legal matrix is already at an enormous disadvantage, right? They don't have the legal training. They don't know how to navigate the procedures and the process. And they certainly might not have a clear understanding of the substantive laws that are affecting their lives. And so they're really at a disadvantage. When you talk about, when you put a racial lens in that context, you're now dealing with a cultural system or a systemic discrimination that has exacerbated all of that, right? That has treated certain people differently because of their race or where they grow up in a particular neighborhood, their immigration status, their disability, who have even less access to the kinds of knowledge that is required to navigate through a very complicated legal system for many, many reasons. Then they face a system that has either been designed or has the effect of not taking what their stories are seriously or misunderstanding those stories. So they face these systemic barriers in ways that really put them, kind of increase exponentially the disadvantage that self-represented litigants already have.
Thank you very much. Thank you for answering all of these questions. Your answers are very eye-opening, thought-provoking, and thank you for sharing all that knowledge. I will now turn to Adelia. I would now like to invite you to provide your perspective. So I'll start with our first question. Where does disability fit with respect to intersectionality?
Thank you for that question. And I'm really glad to have the opportunity to address this, because as I'm going to talk a little bit about, I feel like disability is often erased. And so bringing it to the forefront and having an opportunity to talk about disability in particular within the context of critical theory is something that I'm grateful for this opportunity today. And I also, we were introduced, we're talking from an academic perspective, but critical theories, including critical disability theory, is really tied to experienced and embodied knowledge in a way. Kimberly Crenshaw talks about the origins being in insurgent knowledge, so knowledge from the ground. So I'm going to talk kind of some of the academic frameworks, but then as we discuss over the course of this conversation, it will, I hope, drill down into some of the practical on the ground experiences. And sometimes I diverge and start telling personal stories about things. So I hope that this will be an informative conversation. But in terms of intersectionality, there's a poem actually that I wanted to read. I wanted to share it in terms of the author's original voice, but it's not possible today. So I will tell you a little bit about the author so that folks can kind of imagine who he is. So this was a poem called, it's called The Magic Wand. And it is by a poet, playwright, actor, Paralympian by the name of Lynn Manning. And Lynn Manning, at the age of 23, lost his sight in an accident, and actually, and so that comes into play here, because it's a poem about being a blind man, but also a Black man, and how those things intersect to create a unique experience of oppression and inequality. Okay, I'm just reading excerpts here. I've shortened it a bit. So The Magic Wand by Lynn Manning. Quick change artist extraordinaire, I whip out my folded cane and change from Black man to blind man with a flick of my wrist. It is a profound metamorphosis. From God-gifted wizard of round ball dominating backboards across America to God-gifted idiot savant pounding out chart busters on a cockeyed whim. From welfare rich pimp to disability rich gimp, and from white man's burden to every man's burden. My final form is never my choosing. I only wield the wand. You are the magician. So what I really like about that poem, not only is it a really beautiful way of expressing what intersectionality is when we bring the disability lens or prism into the conversation, but it's also very much about, that last line, you are the magician. It is about the perceptions and the actions of others that create these structures of oppression. And so it's a really, I think, important piece. But the other thing, I mean, to think about in terms of intersectionality, and I mentioned before that disability often gets left out of the conversation, and I'll talk about that erasure. But Crenshaw, when she talks about trying to figure out what the identity axes or intersections of kinds of structural oppression that need to be considered, what they are, she would say, is there a there? And borrow from another critical race theorist by the name of Mari Matsuda, who talks about asking the other question. And in Matsuda's writing, she writes, when I see something that looks racist, I ask, where is the patriarchy in this? When I see something that looks sexist, I ask, where is the heterosexism in this? When I see something that looks homophobic, I ask, where are the class interests in this? And so to bring disability into the intersectional lens, we need to ask, where is the ableism in this? And that's a question actually that's left out of Matsuda's list. But I'll talk a little bit also about that evolution. So I think that very much answers the question of kind of how to get how disability relates to intersectionality, but it's also very important to note that disability overlaps with other forms of marginalization, especially poverty. Okay, so Dean Young talked about the feminization of poverty, but we know that the employment rates for folks who identify as disabled are much lower than the employment rates for those who do not. We know that the poverty rates are much higher, okay? And then there is overlap as well with gender. Certain kinds of disabilities are recognized or even have higher diagnosis rates for women versus men, and they are experienced differently. And of course, the experiences of subordination and discrimination themselves are disabling. And so we need to think, what are the impacts of this kind of discrimination on people? So I'm going to talk a little bit more about kind of the diversity of disability, because it's a very complex and dynamic category, but to have all of that in mind and the overlaps is really important. So to ask, where is the ableism in this, I think is the most important piece of that. Oh.
Sorry, strike two. So thank you for your answer. And my next question, what is critical disability theory? And if there are any misconceptions, please, if you could touch on that, that would be greatly appreciated.
Okay, so critical disability theory is, as a field, it's an interdisciplinary field of study, a critical area of study. So like Dean Young talked about, that importance of looking at things from the lens, the prism perspective of the people who experience ableism in this case. And looking at, so the idea is we look at disability as an embodied difference, just like race, gender, etc. And then we center these bodies in order to explore and theorize social, cultural, and political understandings of disability as a concept and what it means to be disabled. There is, I mean, it's a vast field and it's interdisciplinary in itself, but one thing that kind of has galvanize this area of critical disability theory, some people call it CRIP theory, is the differentiation, or the acceptance, I should say, of the idea that disability is socially constructed, that it is about the relationships, and it is about that we have with each other and within our social structures that creates the disablement. So somebody may have a difference, a physiological difference, or it may also be related to health and illness, impairments, etc. But that it is not about changing the individual. The responsibility doesn't lie there. The responsibility lies within a larger social context. And I think what people might find surprising is that even though we talk about, the individual or medical model, you may have heard that term, versus a social model, and we accept the social model as inherently part of critical disability theory, there's still a variety of perspectives within that. There isn't one unified voice. So even, for example, to talk about feminist theory, and we've seen over the years, clashes from various feminist perspectives, we can have those clashes within disability and social model as well. And then we now have something called disability legal studies, which you had mentioned in your introduction, and bridges together critical disability theory and critical legal scholarship to create a way of a lens by which to focus in on the role of law as a social and structural force in the construction of disability as a marginalizing identity. So here again, we center disabled bodies, lives, and experiences to contextualize and critique inequality, while also offering ideas for resistance and transformative change. And we call this sometimes cripping. So you can think about how to crip or change situations and structures by thinking about it first and foremost. How does this impact somebody with who is disabled or with a disability? So the tenets of disability legal studies, we incorporate that it's a social disability is socially constructed. We center the experiences of disability as a lens to understand law and legal systems, take an expansive approach in terms of what we consider to be sites of law, because again, as was discussed, the law is contextualized within a larger society. And so then it's not just about legal rights, okay? And we aim for actual transformative change. We don't, when we're doing disability legal scholarship, it is not simply the describing of what's going on, but also trying to come to terms with proposals and solutions, which I think brings us to some of the other questions.
Thank you. Thank you. And actually the other question, the next one, there are a number of other issues that are worth discussing. Among them are acquired disability, undiagnosed disability, access to justice, and that's access to justice in the sense of physical access to justice, as well as substantive access to justice. Can you please share your thoughts on that?
Yeah, and I think that that last piece about access to justice does relate to some of the other questions. So I'm going to focus in on the idea of what makes disability complex, and for me, an interesting and fun area to work. But disability is an extraordinarily complex and dynamic category. The experiences are extremely diverse. We have different types of disabilities. We even have conflicts between what might be seen as different categories of disability. And even within one, a diagnosis isn't, the experiences of a particular illness are not going to be the same as for one person as they are for another, and the context also matters. So there are, I mean, and also people don't necessarily identify themselves as being disabled for a variety of reasons. So, I mean, you talked about acquired disability. And so there may be people with particular diagnoses or where there is no diagnosis, but they know that there's something different that's happening. And so people might not even come forward. So we talk about in Canada, the statistics are that about 22% of Canadians over the age of 15 identify as disabled. But I think, you know, that's the low end. Because again, a lot of people don't identify as disabled, and the stigma around disability is so prevalent that it discourages a lot of people in a lot of contexts from either coming forward with that identity or desiring to have that identity. I mean, it's extremely complex. So we talk about there's not only the intersectional issues, but also intrasectional issues here. It's divided up into many component parts. And I mean, we're living in a very interesting time now with COVID and the pandemic, because we're kind of getting to see some of the conflicts and evolution that's happened over time. And we see how disability is contextual and how it evolves with the new diagnosis of long COVID, which people are talking about. But, you know, forever, as long as there have been people, as long as there will be people, and as long as our societies change, there will be new circumstances, new illnesses, etc., that come up, and we don't always have a name for these things. And so we have to think creatively, and we have to realize that it's a really complex identity category, and that people are not always forthright about. So then what are, again, we come to the social model. What are our obligations when we're providing services, when we're interacting with other people, to be able to accommodate these differences?
Thank you. And it's very important that we keep in mind the stigma about revealing one's identity when it comes to disability. So thank you very much for highlighting that. Mm-hmm. Now, my next question, what do you want tribunal adjudicators and leadership to know about their structures and policies impact all stakeholders involved in their proceedings? Mm-hmm. And that in terms of stakeholders, just is the same question I had asked Dean Young. Yeah. Talk about parties, self-represented litigants, counsel, adjudicators, etc.
And I'm gonna fudge the answer for this one a tiny touch as well, because I mean it gets to the issue of access and substantive outcome, and without procedural, without addressing any of the barriers that exist in terms of the process, we're not going to have fair outcomes. So that is an important part, even just to acknowledge that piece, that it's an ongoing process to get those results. And just like, you know, we can't be colorblind, we have to also ensure that we're acknowledging disability. And I think we need to change our assumptions, as opposed to assuming that we are dealing with people who do not have disabilities. We should change our assumptions and understand that everybody is different, and that some of those differences may be due to disability that they're either not disclosing or are not even aware of themselves. Having, you know, I talk about tossing assumptions aside and being open to asking people what they need. Now, I did a little bit of crowdsourcing before talking today, and I asked some folks, you know, what would you want adjudicators to know? And somebody said, you know, what's funny? I find that when I ask people sometimes about accommodation, they say, no, I have a place to stay. Okay, so this is getting at the root of the language, because we don't mean do you need an accommodation in terms of lodging. We mean, what is there about this process that is a barrier for you, and how can we remove that barrier? So sometimes we need to be very explicit about how we talk about these things.
Thank you. And the last question, how can we better design tribunals to be accessible to everyone and meaningfully respond to different voices?
Mm-hmm. It's difficult even to think about, you know, there's no checklist, first of all, because things are changing, but we can look at best practices. But one of the things that that comes up in my head a lot is from my beginning first day of law school. And I was very lucky. I had Constance Backhouse, feminist, historian, amazing, teaching the class. And I sit down in class the very first day, and she says, she asks us a question. She asks us, will you be able to admit that your views were wrong? As you grow and as you learn, will you be able to look back and admit that your views of things were wrong? And to me, this idea of being able to evolve, change, see that things were imperfect, and always be looking to improve and admit our mistakes really is the key to trying to design accessible services and tribunals. So we could talk about, you know, that this kind of humility is really important. And I could go through lists of ideas, but rather than doing that, and also because I'm conscious of the time, right, we need to think about assistance and as being important for access, that we're not providing people with advantages, and look at what some of the best practices are and what maybe some of the recurring things are that are happening that become barriers, and inform ourselves, be ready to listen and be ready to look and dig. So actually in January of this year, it's a great center. It's one of the links that I shared, the Law, Disability and Social Change project at the University of Windsor Faculty of Law, which is headed by Laverne Jacobs, in January, they published a report on the Social Security Tribunal's Navigator service. And they did an analysis. They interviewed navigators, they interviewed people using navigators. And so what that essentially is for self-represented litigants, they can have access to someone to assist them through the process. And they made recommendations, even when we are trying to do our best to accommodate, there is still always going to be a better. There are still going to be questions that haven't been answered. So one of the things that they talked about in the report in terms of the findings was this need to acknowledge multiple or intersecting identities, multiple marginalization, and even to go and help people at home sorting through the piles of paper, like down to that level of detail. So it's just there are a lot of different ideas and things out there, but it's getting the conversation started and doing away with our assumptions.
Thank you. Two more questions, sorry. A lot of self-represented litigants come before administrative tribunals. Can you talk about how we should view the power dynamics through the lens of critical theories?
Yeah, I mean, and I tried to actually blend the last answer together with that one. But I think if I were to add to it, I would caution around ideas of efficiency, okay? Things that we prioritize, are we putting things ahead of the needs of people? And if we're not, again, as I said, not having a fair process, we're not gonna have a fair outcome. To think a lot about what our perceptions of disability are and what some of our maybe assumptions about how people interact is also really important. So what do we view as being professional? When do we see people's behavior as being suspect, and when is that related to disability? So for example, a friend of mine who is a lawyer and identifies as neurodivergent said, eye contact can be a huge problem. So and then people suspect that, you know, that I'm not, I'm not being professional, or I'm not telling the truth. So we have to actually acknowledge these things. Again, that report that Laverne Jacobs and her team put out talks about the need to maybe do the education, maybe bring in consultants and actually evaluate how things are, how we are doing things, how we are operating, what language we're using that we might not even be aware of, privileges some experiences and lives over others.
Thank you for adding that additional information, and thank you about talking. Thank you for talking about that report, and the idea of bringing in consultants. I think is a great idea. So thank you for sharing that with us. The last question: do you have any recommended readings for our audience?
Yes.
They'll be provided in the chat.
And I'm just gonna say, as kind of, you know, an up-and-coming scholar, to have my name on the spine of a book is really exciting. But Law and Disability in Canada, which again, Laverne Jacobs again spearheaded, it's the first book of cases. It's the first case book that focuses on disability in various fields of law. And I think that it's really important that we're actually doing this work. And then one of the things that I recommend to my law students actually is this kind of little known publication called Disability Politics and Theory by A.J. Withers. And I like it because it's very like it's a Canadian context, and it goes through the different ways of understanding disability and what the outcomes of those different understandings are. So in really practical terms, and relating it to legal systems. So what does it mean if we see it as an individual issue as opposed to social, and how do the outcomes change?
Thank you for sharing these titles, and to the audience, we will provide a list with these titles so that anyone who's interested in reading them will have all of the information needed to either purchase the books or borrow them from a library. Adelia, it was such a pleasure to hear everything that you had to say about disability theory. Thank you so much. I've learned a lot. And now our next speaker, Patricia. Now you do have, so as I was saying earlier, so it's a two-part presentation. First part, we had Donna and Adelia talk about the speaking from the lens of academia. So now Patricia will, for us who are looking for practical ways of applying these theories in our day-to-day work. So Patricia will be helping us with that. So we do have a few questions, of course, for you as well. Just bear with me. So the first question, Patricia, how can or should we bring together academia and practice in the administrative justice sector? And then in order to answer the question, we'd like you to keep in mind that some adjudicators will likely say that they are only bound by the evidence before them and only bound by the legislation. So how can we take what we've heard from Adelia and Donna and apply it to the role of an adjudicator?
Good afternoon, everyone. And Donna and Adelia are hard acts to follow. And so I'm going to try to keep it as practical as possible. But first, I want to thank the CCAT, previous home, the organizers, for inviting me in this space. And so I bring with you today more than just administrative justice experience as a decision taker. I bring with you as well the lens of an observer and the lenses of a judge. Donna mentioned earlier in her discussion about in the 80s and 90s, when the courts began to see certain matters, for example, sexual harassment, sexual and rape, etc., basically crimes against women, through a different lens. And perhaps what they didn't know then was they were seeing it through an intersection lens when they tried to build out on the rape shield case and all that different, those different approaches they took. And I want to say, and as I go along, I'm going to give a bit of a summary of what Donna and Adelia said to further my point. And so I'm going to begin by saying, essentially, critical race theory, it began as a practice of interrogating race and racism in society. And we know where it came from, academia, legal academia, and then it went into other fields. And so it's not about diversity and inclusion, and it's not training. What it is a very powerful tool to critique how the social construct of race and structural or systemic racism help to perpetuate a racial system that dismisses Black people, Indigenous people of color, the personhood, and put them at the very bottom of society. And so once you hear that, you ask yourself as an adjudicator, I am given the responsibility to take decision based on law, whether it's jurisprudence or rules or whatever have you. And that is my only obligation. But that is not your only obligation, because in the background of all of this, as Donna mentioned before, is the very gentle, I say benign concept of Canadian culture of being, so virtuous, as Justice Judge Laura Bay mentioned about Canadian values. And yet, even in the face of those Canadian values, we still will not take a strong approach to the elimination of discrimination or be more intentional about taking proactive steps to deal with discrimination in all our justice systems. So we have that. You have that dichotomy, I call it, value on one end and action, basically action-free on another end. And so what I'm saying now as an adjudicator, bringing all of that, what that means, it is challenging me and should challenge you as an adjudicator to reflect on the practices that you did in the past. And as Delia mentioned, it's not just about substantive law. I say it's trans-substantive because you have to look at the processes, because the processes get you to the outcome. And we'd like to think within ourselves that our responsibility is just to interpret laws. I say no. A law or a legislation or regulation has no life, but the life we breathe into it. And we are given concepts like fairness. We are given concepts like beyond a reasonable doubt. We are given concepts of on the balance of probabilities. And we're given concepts about the reasonable man. I think that is prohibited these days. So let's say the reasonable person. And who's the reasonable person here? Reasonable white person? Or who's the reasonable person? A reasonable disabled person? A reasonable Black person? All of those different concepts. So what that tells you, it really tells us that we have more to give, or we are more active in our justice system than just the interpretation of laws. Because when we interpret laws, we use our God-given perception of things, and those things come from our conditioning as children, conditioning from going to school, and they're often premised on a very strong, dominant society. And I'd say a white cultured society. And those are the concepts that we bring when we say we interpret laws and we are going to apply the laws. And as if it isn't bad enough, we in certain cases, for example, in criminal law and sometimes in civil law, we are limited by the evidence that is so critical to assist the decision taker in coming to a decision. We've got all these substantive formalities of hearsay. You can't bring it here. Or it has to be, the person has to be dead before they can accept it or hearsay. And they're all different kind of rules. But the fascinating, and I think that the administrative justice system has an extra tool. And that tool, again, comes from critical race theory, because the critical race theory takes the lived experience as evidence, and thus it's integral to any decision taken in the justice system, particularly in civil and criminal, and more so the latter. And at this juncture, although you may think it's not relevant to administrative justice system, it is relevant in the process and what the outcomes can be. And I bring to your attention the Gladue case, the criminal case, where the court had the backbone or the spine to look at stepping out of traditional ways and look at this indigenous person. And from that, and we don't have enough time for me to take you down that, well, it wasn't a rabbit hole because it had a good outcome. But I don't have the time to take you down that path to say how that Gladue case brought very strong and positive results to the criminal justice system, especially when we are dealing with indigenous people. And I can say that that is not limited to indigenous people. That substantiveness could be applied to anywhere. And so I think what critical race theory is doing for us, or decision takers, it's forcing us to reflect on the practices that we had in the past, the policies that we passed, the legislation that we passed, and we've got to ask ourselves, are we addressing the rights and justices of people who appear before us? And so what I think that this is essentially doing for us, as Delia said, that when you ask the question, you have to ask about, you're talking about disability, you ask about ableism. And so in this sphere, and I'm just saying, what's the justice in all of this? Or the injustice, if we just take a very single axis approach to looking at justice for people who appear before us. And so I remind you that in the application, in the interpretation and the application of laws and rules to the evidence that we hear before us, the lived experience, we see how the human construct of inherent bias and unconscious bias creep into our interpretation and application, and thereby the outcome of things.
Thank you very much, Patricia. Oh.
I'm actually not done.
Okay, sorry.
Because I wanted to expand to something quite important. At the Human Rights Commission, and I'm going to hasten up because you may not be able to ask me the other questions that are coming, and I'm just going to say the critical parts. In Canada, though, in Ontario, though, we have the Ontario Human Rights Commission, who has, I'd say my first recognition of that, it was in the case of Baylis and Flannery, of a young woman. And we can see that the Ontario Human Rights Commission has actually focused and have created policies on intersectionality, and it has created policies that enable us to include in decision-taking the different factors present in a person when that person is dealing with any form of discrimination. And it doesn't necessarily mean that I present you with a case on disability and you look at me and just say it's a disabled case. No, you have to look at the whole of me as a person and address that wholeness. And that is what critical race theory forces us. And I say force because the only opposite side to it is, pushing against it. And so that is now forcing us to rethink the methodologies of our analyses and the methodologies of how we receive, analyze, and evidence and the application therefore. I also want to look at as well a significant system in that we haven't perhaps take for advantage. We have in addition to the Ontario Human Rights System, those are two different provincial levels. We also have the framework of Legal Aid Ontario and its progenies, where we have a whole body of ethnic legal clinics, I call them subsystem, that is driven by lived experience of the people that they serve. And so by representing their clients through these non-traditional lens, it enables a different type of advocacy before tribunals and courts. And these community law lived experience interaction inspires and plants seed that germinates and grow into different types of legal advocacy and social and economic movement. For example, like poverty that Delia and Donna mentioned about, homelessness, mental illness, and substance addictions. And so that method fosters community empowerment, and that could chip away at systems, our systemic inequality, and plant concepts of equality towards lasting transformation of our justice system. And we have to put a whole lot of commitment and energy in that. And I think for me too, that critical race theory, what it is doing, it's causing us to reflect on what we did in the past and reimagine new ways to serve people. It's all about us serving people. It's not about us and our egos and where we come from and the amount of money we have and the richness we have. And one of the best ways to do that, you can't make a rule and then tell somebody, Adelia, is this rule good enough for you? No, that's not service. That's ignorance, arrogance, and presumptiveness. I say you consult with the people that you need to serve and you collaborate. So at the end of the day, you have a clear picture of what the outcome ought to be. And for me, that's critical race theory.
Thank you. And I love the idea of consulting with others. So thank you for highlighting that, Patricia.
And collaboration.
Yes, extremely important to hear everybody's voice, right, before you start creating or establishing policies. So thank you for highlighting that. I noticed it's 2:13. There's another question I'd like you to touch on, and we'd like to be able to take a few questions as well. What is the impact of not taking these critical theories into account? So not only the critical theories, the notion of the concept of intersectionality. So what's the impact when we don't take these concepts into consideration?
I could answer that in one word: injustice. That's what it amounts to, because we're only doing half of the work. We're only addressing half of the person, or maybe not even a half of the person who appears before us. I verily believe justice is about addressing the concerns of that whole person. That's what we say we do, right? We put the person back into the position where they were before. And you can't do it by just addressing one ground. You have to address the whole person. And I take you to, I think the whole concept, and Donna raised that before, about the sum of the whole. And it's something that attributed to, I believe, Aristotle. And some time ago, I think a gentleman by the name of Ross tried to grapple with it to give us a better concept of what it was. And I quote, he said, in the case of all things which have several parts, he didn't say some things, you know. He said all things which have several parts and in which the totality is not, as it were, a mere heap, but the whole is something besides the parts. There is a cause. For even in bodies contact is the cause of unity in some cases, and in other viscosity of some other such quality. And he's saying, you can't cut a person. People say to me, in fact, I digress to give a story. And although I have lost the anger that I felt at the time when it was said to me, I remember it now as a joke from Saturday Night Live, when a professor said to me at Osgood, Patricia, you are not a Black woman. You are a woman who happened to be Black. And that shook my root, not my confidence, because I fired back and said, how dare you think you can define who I am? But I think that essentially that's what we do when we fail to look at the holistic lens of people who appear before us. That privilege that we have to right the wrongs, we must take it very seriously and look at the whole person to put him or her back in the position that they were in before we stepped into the adjudicative ring.
Thank you. I love the one word, powerful answer, injustice. So thank you. There's one question I'll ask. You might have touched on it before. So if there's anything to add, it's 2:17, but if there's anything to add from a practitioner's perspective, are there any misconceptions about these theories that tribunals, their leadership, and staff should be prudent about?
Again, I'm going to be pretty short because I think that Donna and Adelia has really give that background of where those problems or misconceptions come from. Number one, as I mentioned before, people think that CRT is a training tool. No, it's not. They think that it is about diversity and inclusion. No, it's not. As we said, it, in fact, as I mentioned before, and at the risk of being redundant, it is one of the most critical tools that we can engage to look at how just are we in meting out justice. And again, I bring you back to GLADU and what GLADU did for us once the courts were ready to take that intentional step. And we now have GLADU courts. We also look at the court's decision in Lee, R versus Lee, how they were able to look at it, and they probably didn't know they were doing that, but I know they were, through the eyes of critical race theory, and came up with a definition of over-policing. And those are critical. Those are critical and significant steps. And they're not enough. We need to do a whole lot more.
Thank you.
And then you talk about their self-represented. And I would be remiss if I depart this scene without mentioning them. And I can tell you there's guidance. The Supreme Court of Canada said in a case called Pinte versus John, that the situation of a self-represented must be taken into consideration by the decision taker, by the trial of fact or the review court or whoever that case might be. And essentially what it did, it adopted that after it looked at the National Judicial Council had a research on how the self-represented people fared or not in these legal spaces. Because they not only had problems with substantive law, and this mountain of legalese that they have to swim through, they also have problems with the transubstantive. By that, I mean processes. So they appear before the court like lost. And if I had time, I could give you many, many stories where I struggled between the dais and the witness box in ensuring that I didn't step into the fray, but was active enough to assist the person in understanding the case he or she had to meet. And I was met with a lot of resistance and criticism that I was helping the other side. And so I did, rethinking things. I thought, so how do I do that? And I did that, I would say, when I was at the Immigration Appeal Division Court. And I should mention that the Ministers' Council took it quite gracefully, because I would call on them to explain certain things and just remind them that you're here for the people and this person's a part of the people too. And your job isn't to make a case. Your job is to explain to me how and give me, guidance how to get there. And those council, and they did. So, okay, sure. And they would explain. But again, I talk about reimagining things. And I think at God, I can't believe I'm going to use this word, but at the intersection of the George Floyd murder and the global response to this rather abhorrent action, and the catalyst as well of COVID-19 and his vagrant brother Omicron and in all his forms, we were given a significant opportunity to reflect on what we did in the past, to reimagine the way that society is now telling us that they want us to deliver services to them, reset the dial to ensure that we are responding to their needs and to produce the results that they're seeking.
Thank you. This is very interesting discussions. I think we could talk about this for many more hours. The last two questions I have for you, Patricia, I could put them into two simply because I believe you've touched on these items earlier. So the next question was, have courts and administrative tribunals dealt with critical theories and intersectionality either directly or indirectly? And the last question was whether you have any recommended readings for our audience. So I know you have talked about Gladue, you have talked about Pinta. I think there was a third case you might have mentioned.
Pinta versus John. I mentioned R versus Lee. And administrative, and I tried to do this because I'm watching the time and I was hoping that we could have had questions as well. And I am going to take it upon myself to give you these references. In fact, let me say this. We live in an age of technology, and whenever I want a case, the first place I land is on the internet. I go and I look for it. And I probably did.
And while you search, we do have two questions that we could ask.
I think I had the reference here for the Gladue case, but I can assure you that you go in and you can find it on the internet, or can Lee. And as legal people, you can find it there. R versus Lee is a criminal case, of course. And the Pinte versus John, Pintea versus John, is a Supreme Court of Canada decision, and I'm sure there is not another one, and you'd be able to find it. And so recommendations for adjudicators. And I think a lot of it, if you listen carefully to Adelia and Donna speak, just pick the things that they say that are so unkind in the scheme of administering justice, and ensure that your tribunal does not do any of those things. And I think that's the very best way to start. And I know there's a whole lot of tribunal training, including this. And one of the things I want to remind you of, that people think that or take it for granted. We have the an Ontario Human Rights Code, which holds the status of primacy of all provincial legislation. It gives you guidance in everything you do. And what's more, it's built policies that you can follow, and you don't have to pay for it. It's on their website. Oh, the website is a mess, and we are trying to organize it. And by the way, I'm going to digress to say this. We have put out a call to everyone to say, give us comments about our website. It's made for you, and tell us, that's consultation, right? Tell us how you want that website to look so that when you go there, you can find things. So you go on the website and you're going to find a whole lot of policies there and statements. And I'm going to tell you this, the Supreme Court of Canada has said in several decisions that the Ontario Human Rights Commission holds our experts in human rights. And I would say, since it is the governing legislation, when you're building policies, when you're building practices, consult with it. And I tell you something, this is so significant that in the Human Rights Code, it tells you that if the Ontario Human Rights Tribunal, Human Rights Tribunal of Ontario, takes a decision that is contrary to a policy issued by the Ontario Human Rights Commission, it can be hauled into a reviewing court to explain, why did you deviate from that policy? So make it your friend and make us your friend. In my tenure, one of the things I want to do is to explain to people and entreat people to understand the relevance of human rights in your own personal life. You move away human rights institution and you live in chaos. We're all about making government function well. It's all about, as we say in constitutional law, peace, order, and good government. And make no mistake, we try to do all of that. Very small acts, 33 members with a $5 million budget, but our focus is making Ontarians' rights better, promoting the dignity of human rights, and doing that balancing of competing rights to ensure that we truly exemplify the Canadian values that Baker talks about, and that we really do something instead of platitudes. We really want to do something to make a difference.
Thank you very much for reminding us that we do have human rights legislation that is actually considered quasi-constitutional legislation that we should all be applying, and we should not all know that legislation intimately. So thank you for reminding us that that should be like our first stop when we decide to put forward policy or work on policies in order to make sure we're able to take into account these theories that we've discussed today. So thank you for that reminder. And
may I be so bold to make a comment? The Ontario Human Rights Code turns 60 on in June, and we're having a celebration. I'm asking you to follow us on LinkedIn, those of you on LinkedIn, and it's going to be virtual. And we're in collaboration with no institution other than TMU. Yes. And one of our keynote speakers is the inaugural Dean, Madame Donna Young, along with Cindy Blackstock. So folks, please come and join us to celebrate you, because it really is all about you.
thank you. And what is the date?
The ceremony is June 23rd.
June 23rd.
And we just
Thank
sent
you.
out the save the date, and we're having awards on the 15th.
Thank you.
And that too will be virtual, but
Thank you. Thank you for bringing that great event to our attention. So we do have one question that we can get to. I notice it's 2:29. So there's one question in the chat. How does critical theory differ from applying a particular lens or perspective in decision making? Not sure who's comfortable taking this question.
I think I can do. I think I can say this really quickly. It is critical theory is saying that we have to recognize that there is a particular lens when the normal assumption is that there is not, so that there is no lens. You know, it's a neutral or objective decision-making body or decision maker, when in fact what critical theory says is there's always a lens, and it could be a lens that we don't, that kind of appears to be invisible, but it's always there.
And it also causes us to know that there is not such a thing as a neutral lens, because neutral from whose perspective? And we must be mindful of that.
Thank you very much. Delia, is there anything you'd like to add to Donna's and Patricia's comment?
No, I mean that they're really capturing it, but I think I was reminded actually of this phrase. I have a 5-year-old, and so we watch a lot of Disney movies, and there was a phrase in one movie that I actually find to be quite helpful when thinking about how to move forward with all this stuff, because sometimes, you know, we do things with the best of intention and then we find that there are better ways. So it's Frozen 2, where the princesses discover actually that they are responsible for horrible acts of colonialism, essentially, against the indigenous people. And what do they do about it? And so they say to each other, do the next right thing. And I think that that's a positive way to think about this stuff. So do the next right thing, because there were questions about, you know, how do we make tribunals accessible when people aren't necessarily out. We can't do everything. We need to work with the best of intention as we move forward and be open to doing the next right thing.
Thank you. So be forward looking. Thank you so much for sharing that. It's 2:32 already. It has gone by so quickly. Thank you so much. It was such an honor and a privilege to have all of you three awesome experts. Thank you for sharing your time with us. We know you all have a busy schedule and a lot of work, a lot of great work that you're doing for the community. So thank you for taking that time, sharing your expertise, giving your insight. We're very grateful for you being here today. So, so we're pleased to announce that as a token of our appreciation for being with us today, we'll be making a contribution. So CCAT will be making a contribution to the National Self-Represented Litigants Project in your honor. So thank you. And the next and final session in the symposium series is how to access your justice, tips to improve tribunal design. So we had a bit of an introduction when Adelia talked about the report from Ms. Laverne. So we are going to be discussing that next week. So hopefully you'll all be able to join and attend that session. And that will be, you'll be receiving the login details on Wednesday, May 11th. So please check your spam or your junk folders if you realize that your general inbox, you've not received any email from Cindy. And if you have any questions, please email Cindy at info@ccat-ctac.org. Thank you so much. It was a pleasure having you. I've learned so much. I hope that the audience enjoyed the session as much as I did. And for those participants who are looking to have a list of all of the references that were discussed today, we will be sending that to you shortly. I hope everybody has a wonderful rest of the day and that you'll be able to ponder on all of the great topics that we were able to discuss today. Thank you very much.
Thank you for inviting me here.
Thank you.